Jennifer, are you going to start?
I am going to start. I don't see myself. I still see the slides. That is why I was hesitating.
Do you want me to unshare for a minute?
I want you to unshare for a minute. Yes. There we go. Okay. Well, hi, everyone, and welcome to the first Legal Network for Gender Equity and Time's Up Legal Defense Fund webinar of 2021. I am really thrilled to introduce this topic today. You all saw the title in the announcement. We're at the 3-year anniversary of the Time's Up Legal Defense Fund and felt that this was an opportune moment for so many reasons to think about whether it is time to push the boundaries of the severe or pervasive standard in workplace sex harassment cases. I am not going to tell you all of the interesting things that our fantastic speakers have done because it will take a long time, but you all should have gotten a copy of their bios, and that will be posted on our website along with a recording of this webinar for you all to peruse later. I want to thank our speakers, though, for sharing their expertise and helping us to develop this webinar. I also want to extend thanks to all of the attorneys in the Legal Network for Gender Equity for everything that you all do to help us bring justice to survivors of workplace sex harassment. You all are making it possible for us to do what we're trying to do with the Time's Up Legal Defense Fund. So thank you for all that you do and for being interested in pushing the boundaries of the law and tuning in for this webinar today. A couple of housekeeping measures before we get started. We're going to hear from each of our speakers in turn, and then there will be a good amount of time for questions at the end of the webinar. We're going to try to leave about 20 minutes for questions. So if folks have questions, as I expect that you will while you are listening, the best thing to do is to send them to us in the chat. We're going to keep an eye on the chat, and I will bring up questions that are posed through the chat at the end of the session. If you have any technical issues, you can send them to us in the chat too. The way that we're doing this is you'll be able to see and hear all the speakers. We can't see you, so don't speak up with questions. Just go ahead and send them to us in the chat. So thank you all again for tuning in. I think without further ado, I will turn it over to Professor Williams to get us started.
Just going to share my screen. Do you see the screen?
Yes, we do.
Okay, super. For some reason, it's not going into slideshow. Oh, does it appear to be in slideshow on your screen?
Well, it's showing us, I think it's the same view that you have. It looks like you're choosing slideshow or resume slideshow are the options.
Yeah, it for some, let me see, resume slideshow. This has actually never happened to me before. Let me try to close it and then open it again. Sorry.
Okay.
Okay, opened it again. Let me go back to where you are. I will try once more, and if this doesn't work, then you guys will, I'll hand it over to you folks to do the slideshow.
Okay. And Professor Williams, you know, I didn't want to take time with introductions, but since I did that, I haven't said who the people are that everyone is seeing on the screen. Can you just introduce yourself very briefly before you get started?
Me or everyone? Excuse me, is this a proper display now? Do you see the slideshow?
I think that it's fine the way that we see it. We see your current slide and your next slide at the same time.
Okay, well, we might as well just jump in. Okay, I'm Joan Williams. I'm a law professor. I'm going to jump in because I know I just wasted like lots of everybody's time. So I wrote an article last year on sexual harassment called "What's Reasonable Now?" And the reason it's important is because typically social norms change very slowly, but much more rarely there's an abrupt shift, what we call a norm cascade. And that's exactly what happened in sexual harassment. So in 1998, if you ask people, is sexual harassment a serious problem? Only 34% said yes. But then shortly before Me Too, many years later, only 42% said yes. But then during Me Too, 64%, and by January 18th in 2018, about 3/4 of people said yes. So there's been a very sharp understanding, change in what people's understanding of sexual harassment is a serious problem. In 1991, and this is of course Professor Hill, when she testified, she got what we call the vengeful lying slut stereotype thrown at her. She was asked, are you a scorned woman? There's the vengeful, and a little bit nutty and a little bit slutty. There's the whole stereotype. So that was very strong in 1991. And then you had Me Too. And within 48 hours, here's the original tweet, Me Too had been tweeted 1 million times. And so it's had profound impacts. For example, if you ask people in 2013, 3/4 of women said that reporting sexual harassment is a risky career move. But in 2018, that had fallen to under half. And very importantly, by 2018, after Me Too, 2/3 said that the victim is more likely to be believed than the accused. All of these facts are really important as judges try to guess what a reasonable jury would find today. And all of this data is in the law review article. So a zero tolerance policy for sexual harassment is essential. Strong today, 3/4, nearly 80% of Americans either strongly agree or agree, zero tolerance. That's also very important because of stuff both I and Jen will talk about. Tiny amounts disagree. And there's broad agreement also amongst men and women. 96% of women and 86% of men say groping or touching is sexual harassment. 89% of women, 83% of men masturbating in front of somebody. 89% of women, 76% of men exposing yourself, sharing intimate photos. 85 women, 71 men, explicit texts. 83 women, 69 men. So that's the first time you've seen a significant difference between men and women. This one is super important. Sexual comments about someone, 86% of women, but also 70% of men. So if you define majority as what's reasonable, you have very broad agreement between men and women. Also, I just wanted to bring this to your attention, this study to your attention. It's a study called Sexual Behavior at Work, Fun or Folly. And it found that only about 10% of women enjoyed sexual behavior at work, including joking, whereas nearly half of men did. But very importantly, even employees who enjoyed sexual behavior at work reported negative effects from it. Negative workplace outcomes like disengagement, and also negative psychological outcomes like anxiety and depression. Another very important factoid. So the basic principle of Me Too is like super simple, as you know. When people come to work, they're entitled to work relationships. Revolutionary. And so what I did is, this is in 2019 Michigan State Law Review, we did an analysis of the most cited sexual harassment cases in the country. And then we analyzed which captured what is reasonable now and which were really out of sync with what's reasonable now. So I'll be talking about the 5 cases that were super out of sync with what's reasonable today. The judge took away the case from the jury in each one of these cases, and they're really out of sync with what a reasonable jury would find today. So the article describes how to distinguish these cases because they're very widely cited. And then it also provides other cases to cite instead, what we call the cases in chief and the cite insteads. Whoops, I'm going backwards. So here's the classic hostile work environment test, which is inconsistent with Supreme Court precedent. This is the way I was taught it: conduct that's unwelcome, then a reasonable person would find hostile, the plaintiff or herself found it hostile, and the conduct must be severe or pervasive. Here's where this some of the operative language. This is from Conco. Conduct that is not severe or pervasive enough to create an objectively hostile and abusive work environment is beyond Title VII's purview. In other words, the severe or pervasive language in its original articulation, actually this is on call, but if you read back to Meritor and Harris, same thing, is placed in the context of has to be severe or pervasive enough to such that a reasonable person would find a hostile environment. It's placed in the context of reasonability. And what courts have done is separated off severe and pervasive as if it's unrelated to the assessment of reasonability. That's actually not what the case says. Conduct that's not severe or pervasive such that a reasonable person would find it hostile or abusive. That's what the Supreme Court said. So here's the, this is all the Michigas. I have the slightly outdated version. This is the right hostile work environment test. Conduct that's unwelcome, that is sufficiently severe or pervasive that a reasonable person would find the environment hostile, and the plaintiff found it hostile. So what's reasonable now is different from what was reasonable before Me Too. I'm going to talk about the first of the 5 cases, Brooks versus San Mateo, which is one of the most cited cases in the country with almost 1,300 sites. Now, thanks to Mariko, who will talk to you about this in a minute, it is no longer citable in California for the proposition of what constitutes severe or pervasive, but it is still available in other states, in the Ninth Circuit and elsewhere. And it's also citable for every other proposition. It has a lot of other truly evil holdings. So the facts here were that this was a 911 operator whose colleague, I kid you not, came and cupped her breast, her naked breast with his hand, putting his hand down her shirt, and came back 3 different times that same evening. Such that he was jailed for 120 days for sexual assault, and she went on disability leave, if I remember correctly, for 6 months because she was so upset. And there had been 2 prior instances of the same guy engaging in gross sexual harassment. The retaliation facts are that after this woman finally put her foot down, she was given a negative performance evaluation, denied her desired vacation, her desired hours, and a lot of her colleagues wouldn't talk to her. Well, remember, this is a Judge Kaczynski case. Judge Kaczynski, of course, we all know about him. He was kicked off the court because he had done lots of these things, including groping and porn. But he found no sexual harassment, no retaliation. So this is completely not what a reasonable jury would find now, even if it was then, which is doubtful. Groping, the assumptions in Brooks versus San Mateo are that groping is not necessarily sexual harassment. That's not what people believe. That sexual harassment is not serious, even if it's actionable criminal sexual assault, and that employers shouldn't be responsible for sexual antics, that an employee should just kind of suck it up. That's not what a reasonable jury would find on these facts today. Also, Brooks said that a single instance may never be enough to prove sexual harassment because it's really not fair to the employer. They had no notice. I mean, that's a little weird. First of all, this employer had notice, as we'll talk about in a minute, but he focused on the word permeate, that if a single instance sexual harassment doesn't permeate the environment. There is the quote from Harris. And Harris did use the word permeate, but Harris and the other cases also said that you have to look at the environment as what a reasonable person in the plaintiff's position would find a hostile environment. And again, going back to the polling data, this kind of groping would be seen as unreasonable to reasonable people today. Also, as I mentioned, Kozinski said it's unfair to hold the employer liable because this was an isolated incident, and then the plaintiff can't rely on reports of others because she didn't know about those reports at the time. Well, that's actually irrelevant. What matters for in this issue is whether the employer knew, not whether the plaintiff knew, and the employer had two separate complaints. So as you remember, the standard is a negligence standard. The employer is liable if the employer knew or should have known. So that's just a mistake in the opinion. That's just clearly an analytical error. Kozinski also said that discounted the importance of the performance evaluation, which has been held to be enough to sustain a retaliation claim, and said that it was subject to modification and therefore was irrelevant. Remember, Harris versus Forklift, Title VII comes into play before the plaintiff has a nervous breakdown. This plaintiff literally had a nervous breakdown. That's why she left and didn't contest the performance evaluation. So that case is basically really shoddy if you have to deal with it. Here's the second one. This is an 11th Circuit case. It's been cited about 1,200 times. The facts here were this woman's supervisor basically stalked her, following her around the workplace, all over the place, not outside the workplace, but in the workplace. He stared at her crotch. He did this weird thing where he grabbed her hip, and then he rotated and rubbed her shoulder and hip. So a weird thing to do that is not the basic workplace ricochet. And he said, he at one point he told her, yeah, I'm all fired up too. So that kind of behavior also not reasonable now if you meet with Mendoza in the 11th Circuit and outside, because it's also cited a lot outside. This is this idea of rubbing your hip and grabbing at the same time you grab someone's shoulder. That's sexual touching. And as we just saw, both men and women think sexual touching is not reasonable. Also, the Mendoza court said that it's not sexual harassment absent uninhibited sexual threats. This is big language in the 11th Circuit. This is completely inconsistent with the reasonable person standard, particularly today. A reasonable person would find lots of things sexual harassment that are not uninhibited sexual threats. Also, the court makes a big deal about how we really can't get into this because men and women see these things so differently. Well, the polling data says, no, they don't, not for stuff like this. And it also says mere comments are not enough. Remember the polling data saying that sexual comments are now seen by a large percentage of men and women as sexual harassment. So also that's a way if you're met with Mendoza. Mendoza also used what I call the infinite regression of anachronism. It basically cites a lot of 1990 cases that found no sexual harassment despite groping, despite people staring at other people's crotches, despite abusive language like you're a sick bitch. And it said, oh, this isn't like that. There's no sexual harassment absent extended, long-lasting, unredressed, and uninhibited sexual threats. Well, if that stuff was not sexual harassment in the 1990s, it's certainly sexual harassment today. So saying, oh, this wasn't sexual harassment in the 1990s, so it isn't sexual harassment today, that's not what the Supreme Court said. They said a reasonable jury could find that a reasonable person would think this is sexual harassment. So that infinite regression of old cases, it's inconsistent with Supreme Court precedent. It also uses the idea that it's not sexual harassment unless it's physically threatening and humiliating. And we all know where this comes from. It comes from Harris versus Forklift. But if you go back to Harris versus Forklift, those are listed as physically threatening or humiliating, and a number of other things are listed as factors that a court may consider. They are not part of the test. They are factors that a court may consider. And so not only is it inconsistent with the reasonableness test, that's just a mistake in using the Supreme Court law. Mendoza also does what a lot of defense lawyers do, both in the criminal context and in the sexual harassment context, what I call the divide and conquer maneuver, where it just isolates each piece of information. Well, that's actually not what the Supreme Court said to do. It said to look at all the circumstances as a whole. So that's also inconsistent with Supreme Court precedent. And if you meet with Mendoza, keep in mind that not only could reasonable people disagree about whether that was sexual harassment, reasonable people did disagree because there was a passionate dissent that said this is sexual harassment. So that's Mendoza. Third case is Baskerville v. Culligan. This is a Seventh Circuit Judge Posner case, cited more than 850 times. This was the case where this kind of clueless guy mimed masturbation, did sexual grunting, said, oh, does that mean all the girls should run around naked? Or that means all pretty girls should run around naked now. Asked the plaintiff whether she was his Ms. Anita Hill, and said that he better be careful. The people better be careful or he would lose control. So none of this is reasonable now. Mind masturbation, the assumption is that mind masturbation is not sexual harassment. Now, yes, it is. That's what reasonable juries would find. That comments alone aren't sexual harassment. That's wrong. Reasonable juries would find comments alone are sexual harassment. That sexual harassment was not serious absent groping, threats, disrobing, pornography, or and this is a common form of words. Judges say, oh, this behavior was boorish. That's the kind of boys will be boys language, not hellish. Well, the Supreme Court never said that, there's no sexual harassment unless the plaintiff's life is hell. In fact, in Harris versus Forklift, they said exactly the opposite. The plaintiff doesn't have to have a nervous breakdown in order for this to be sexual harassment. Also, good old Posner said, we assume truthfully, where there was no allegation that the plaintiff's statements were not truthful. So that is, again, the assumption, the kind of vengeful lying slut that women are not credible. That's not what people believe today. Next case is Baumann versus Shawnee. This is a Sixth Circuit case with about more than 700 sites. This was a woman on men sexual harassment case. The woman boss grabbed his buttocks, touched him, and propositioned him repeatedly, accused him of lying unjustifiably. Bless her heart, she called him to her house to repair her deck, if you can believe it, and did other false accusations. So this is not reasonable now at all. Again, touching and propositions are what reasonable people today believe that touching and propositions are sexual harassment. And based on the arc of Me Too, people also believe that men as well as women can be sexually harassed. So that's Baumann. Here's the last, Shepard versus Controller. This has nearly 600 sites, Sixth Circuit. Here, this guy was I think it was the brother-in-law of the plaintiff. It was pretty weird. He patted his lap and said, here's your seat. He made lots of sexual comments. He looked down her top and mimed going under her skirt with his hand, stroked her arm in a very sexual way. Again, this is not what a reasonable jury would find today. The test that Shepard articulates is that sexual harassment is not serious unless it destroys women's opportunity to succeed. That's not what reasonable juries would find today. And the assumption is that sexualized touching is not sexual harassment, totally outdated. Comments such as your elbows are the same color as your nipples are not sexual harassment. That's not, look at the polling data. and that there's no sexual harassment unless it's physically threatening. That's treating those Harris 4 may include factors as if they were requirements, which the Supreme Court said they aren't. So again, the court said, oh, this is boorish behavior. It's a mere utterance. The touching was too tepid and not physically threatening. Sorry, it's telling me to shut up. And then we also have the infinite regression of anachronism, that this is far less objectionable where women were quartered, groped, held down, and felt up. So in the legal profession, sexual harassment is linked with delays in promotion, less access to high-profile assignments and sponsorship, bias based on parenthood, higher intent to leave. That's all in the you can't change what you can't see. ABA Commission on Women, MCCA report on the legal profession that I was the lead author on. Thank you very much. I will stop sharing my screen.
Thank you so much, Joan. That was a fantastic presentation. We're so lucky to have had the synopsis of her paper, but her paper is fabulous, and I really recommend for those people who have not read it already to do it. Here's my copy. You can't see it. I slept with it next to my head last night. And it is chock full of fantastic cases, not just the depressing and concerning ones that Joan went through, but in each of those circuits, she has actually identified pivotal cases where the courts have decided in favor of plaintiffs. And so in terms of getting our cases to survive summary judgment, to avoid having jury verdicts taken away from the plaintiff, those are the cases that we want to be citing, and we'll come back to that in a bit. So my name is Jennifer Liu. I am the managing partner of the Liu Law Firm in Menlo Park, California. And I want to start with a quick set of polls. So let's see if I can advance the slides. All right. Okay, so if we can run the poll. First question, I'm curious where everyone is from, and I'm actually not interested in what state you are from, but rather in which federal circuit do you practice? So first, second, third, or fourth, and so on. And then number 2, how many sexual harassment cases have you litigated? Number 3, have you had a sexual harassment case taken away from a jury, either on summary judgment or judgment as a matter of law? And then finally, I've got a last poll question that I'm going to have you guys hold on to and answer after I go through a hypothetical with you. Okay, so I'm going to give folks maybe about 10 more seconds before we go to our hypothetical. Oh, yes, and I know you can't actually submit the poll until you answer the fourth one, so I will let you answer that in just 1 second. Here we go. All right. Okay, so I don't think I can advance the slide, so Anna, can you advance to the next slide? So let's say you are sitting in your office and a PC calls and comes to you with this fact pattern, which I call the Man Haters Club of America fact pattern. So the PC was hired to provide training at a manufacturing plant. Her male supervisor makes romantic advances, which she rejects. Later, he asks her to create a document on his computer, which has a picture of a naked woman as his screensaver. When she needs to hand him the phone, he unnecessarily touches her hand. The supervisor has a planter that is shaped like a slouching man with a cactus protruding from a hole in the man's pants and asks the PC to draw a picture of it. The supervisor shows PC a pacifier that's shaped like a penis. Finally, the supervisor creates a poster portraying the PC as the president and CEO of the Man Haters Club of America and asks her to type a list of beliefs of the club that involve a bunch of sexist statements. So now you can finish the poll. Does it sound like it'd be a slam dunk in any circuit? Does it depend on which circuit you're in? Are these facts too weak? Or for many of you, you may actually recognize this fact pattern. Okay, and we'll give, and maybe we can give people about 10 more seconds to answer the poll. Then if you can roll the results, I'm curious to hear what folks think and to hear a little bit more about everyone's experience as practitioners as well. Okay, so we've got people actually in every region. This is great. And then we have a lot of very experienced practitioners. This is great. And a few folks who have yet to take their first case. So that's great. So a nice variety. And then we have had about slightly less, maybe about a quarter of us have had sexual harassment cases taken away from a jury. And 20% of us think this sounds like a slam dunk in any circuit. 70% say it depends on the circuit. One person thought the facts were too weak in any circuit. And 12% of us recognize this fact pattern, which of course we go to the next slide. Some of you may recognize as the facts from Duncan versus General Motors, an 8th Circuit case from 2002, where the district court granted judgment, a post-trial judgment as a matter of law in favor of defendants, despite the jury siding with the plaintiff. And you'll recognize some of this language. The majority concluded that while the supervisor's actions were boorish and chauvinistic and decidedly immature, they could not say that they to create an objectively hostile work environment. And I feel like that word boorish is a search term that you could put into Westlaw and find, all of the terrible cases. That same language came up in the Baskerville and Shepherd cases that Joan talked about. So, I promise this is the last terrible case that I will depress you all with, but I wanted to start with it because I want to start with the preposition, which is essentially the same as Joan's proposition, which is that this case should survive summary judgment or judgment as a matter of law in any circuit. And if that's not the case, then the law needs to change. We have a bunch of our nation's brightest sexual harassment lawyer minds here on the call. So let's talk about how do we do that? And thinking to Joan's paper and this idea that we've just experienced this norms cascade, where we have the general public believing that things that might have been considered relatively minor in nature a decade ago, the public thinks are shocking and wrong. And so in some senses, this is a historic moment where the gap between what public opinion thinks and what is in the published case law is at its greatest. And so while that is depressing, it's also a tremendous opportunity, because I think now that judges have lived through Me Too and they've lived through Black Lives Matter and a similar norms cascade in racial harassment, that they see these facts different. And I think that could really be an opportunity for changing the case law. So let's talk a little bit more about that. If we can go to the next slide. So I wanted to just offer a couple thoughts as a practitioner, and most of this is old hat to most of you. So I'll go through this pretty quickly. But of course, you want to think about all of your facts when a new PC comes into your office or calls you on the phone. All the different factors that go into severity, pervasiveness. And these, of course, are not exhaustive factors, but simply thinking. And one interesting issue is whether it matters what industry you are in or the nature of the workplace. I personally think it should not matter. However, I wouldn't be above using it if it were helpful to my client, right? And so, you can compare this Gross case from the 10th Circuit that says that speech that might be offensive in a prep school faculty meeting might be tolerated in another work environment, like a restaurant or a manufacturing plant. But then, I find more persuasive, and I think that the trend in the law is moving this direction. And America will have more to say on this in a bit when she talks about what's happening in California, is that it shouldn't matter what industry you're in. Just because women choose to work in the trades does not mean that they deserve less protection than women who work in a courthouse or some other white collar profession. Of course, looking at what is the plaintiff's subjective belief, what's the impact on the plaintiff, and then also, what was the reaction of bystanders? And one of the good cases that Jen picked out in her paper, this Ellison versus Brady case in the Ninth Circuit, when the supervisor wrote this creepy love letter to the plaintiff that freaked her out. And so she showed it to her supervisor. Her supervisor looked at the note and said, "This is sexual harassment." So things like that are obviously not dispositive, but if someone else in the same workplace who is in the same context thinks it's sexual harassment, that's certainly indicative of what a reasonable person would think, right? So thinking about what to do when cases come in. If you have a case like, say, the Duncan, a PC with facts like the Duncan plaintiff, those could be a potential opportunity where, in those cases, you will want to do all the same blocking and tackling that you do in any case where you compare your facts to the facts of other good cases and you distinguish them from the facts of bad cases. But to the extent that you actually have a case where it is shockingly similar to a terrible case, that could actually be a very interesting vehicle. So maybe if we could move to the next slide. So you'll want to, just one before, sorry. So in terms of comparing your facts to the facts of other good cases, I did put together a single, not a single page of paper, but a single document that compiles all of the good cases that Joan sets out in her paper. And then I've also created headers for the other circuits that weren't included in the paper. And I've started populating that with other good cases with good facts. And so what I'm going to do is I'm going to go into the chat and I'm going to paste a link to a Google document. Hopefully you guys can access that. But when we're briefing cases, whether it be mediation briefs or motions for summary, oppositions to summary judgment, these are cases that we can look at to see, well, what are, especially in the last 5 to 10 years, what have circuit courts found to be actionable sexual harassment? And one tip, I find that the best cases seem to come from the First Circuit. Maybe it's the prim and proper culture in New England. I don't know. But some of those cases are great where, they're a very pointed contrast to some of the cases that Joan went through. And those can be really helpful. Okay, so, but of course, bad facts make bad law. And so there are oftentimes, all of us get cases where something terrible has happened to the plaintiff. She has experienced horrendous treatment, but we know that it is not a strong case. What do we do with those cases? And for those cases, one thing to consider if you do take them on is to consider helping the plaintiff explore internal avenues or pre-litigation negotiations, because then it doesn't get submitted to a judge and it allows you to harness public opinion and current norms. Did the harasser violate the internal code of conduct? What is the attitude of other coworkers? Are other coworkers coming forward and speaking in favor of your client? Or what is the attitude of opposing counsel? I often find that if I can tell the opposing counsel feels like the conduct is reprehensible, even if it wouldn't be found to be actionable sexual harassment in a court of law, that you can oftentimes settle those cases. But it does, maybe should give us pause when we have weakish facts to not push them into litigation without a lot of forethought. So finally, know the law and what is the approach of your circuit. And so there is arguably a circuit split right now between circuits that follow a fairly explicit version of what Joan calls the infinite regression of anachronism, and other folks have called precedent comparing circuits. And that is where, and that exists in the 5th and 8th circuits. I know we have a couple of you from those circuits on the call who are probably familiar with this. But that's where the Duncan's cases from the 8th Circuit, the other bad cases from the 5th Circuit. But those facts essentially establish a baseline where the court looks at the facts of your case and says, are they better, are they more or less egregious than these facts? And unless they were equally or more egregious, they say, sorry, not sexual harassment. And it is not quite that clear, but it is very apparent that you have to show a fairly extreme level of harassment in these circuits in order to have your case survive summary judgment. If you're in another circuit, then you can rely on just distinguishing your facts and relying on the law. But even still, in a good circuit, I have yet to see many courts set forth an explicit discussion of the reasonable person standard, just as Joan has mentioned it, that states that the reasonable person standard should evolve over time. And what a reasonable person thought 30 years ago, the reasonable person has not been trapped in a time capsule. That person has lived over the last 30 years and has evolved norms. And so therefore the facts that constitute harassment should over as well. So let's move to the next slide. And this is just an example of what the Eighth Circuit looks like. And then finally, these are just some tips about how we move from this idea. A lot of cases, the circuit courts will say that these terrible cases are not a boundary for what constitutes sexual harassment. And that's helpful language, that these cases don't, Duncan and Brooks, these are not the outlines of what is sexual harassment. But that stops a step short from saying that the reasonable person standard should be evolving over time. And so, and just some thoughts about how we get a bit more favorable case law on that front. And the last thought I'd like to leave folks with is that the right vehicle could just as well be a racial harassment case as a sexual harassment case. I think all of Joan's points are equally applicable to racial harassment cases. And I wanted to share a little bit of language from the next slide, which was a district court opinion coming out of the Eastern District of Virginia. So this is a shipyard case involving a lot of racial harassment. And I actually saw this case shortly after I read Joan's paper, and I just thought, this is exactly what we need. We need more cases like this. And so the judge talks about how it's not just the circumstances and expectations that govern the inquiry, and not only the industry, but the time frame of alleged conduct. And so we have to be careful to not place undue emphasis on the fact patterns of historical cases, as doing so would ignore evolving social norms and could have the effect of sanctioning an established culture of blue-collar racism under the faulty justification that it's always been that way in such industry. So I think referring explicitly to the fact that the time frame of the conduct matters is something that we should be working into our briefs and really encouraging judges to adopt. And a last note is this opinion, for some reason, is still not published in Westlaw. So if somebody in the audience wants to volunteer to get it published by Westlaw, this is something that I think we all really want to be citing in our cases. And I'll leave it there.
Terrific. Thank you so much, Professor Williams and Jennifer. Can you all unshare the slide so we go back to the, there we go. Perfect. This is Jennifer talking again. Now we are going to hear from Mariko Yoshihara and Miriam Clark about strides they have made with pushing the boundaries of the severe or pervasive standard in their state legislatures in New York and California, respectively. So we started out with thinking about how to push the law in the courts. Now we're switching to policymakers, and I thought we were going to get started with Mariko sharing, but I see Miriam's slides here. Okay, I think we are going to Mariko's slides.
That sounds great. Should I just get started?
That would be great. Will you just introduce yourself briefly and then get us going?
My name is Mariko Yoshihara. I'm the Legislative Counsel and Policy Director for the California Employment Lawyers Association. So we have about 1,200 plaintiff side employment lawyers here in California, and we co-sponsored SB 1300, which I'm going to go over with all of you back in 2018, we really jumped on that opportunity at the height of the Me Too movement to really make some policy changes, as we've been hearing was so desperately needed. And we co-sponsored that bill with equal rights advocates. It was really guided by very experienced, amazing legal practitioners. We've come to call the Strike Force 5, Sexual Harassment Strike Force. So hopefully this can help provide a roadmap for those of you in other states that might have the opportunity, and I hope we'll try and seek out that opportunity to change your state's sexual harassment laws. I think the key here, as we've kept talking about here, is highlighting the gap between what our common understanding of what sexual harassment is with what the legal definition is, and really highlighting those bad cases. And I'm so appreciative to Joan's article, because I think you have all the bad cases that you need right there that you really could use to try to make some changes with your state legislature. So that's actually what we did. We first started with an informational hearing, and we went through sort of case by case all of these bad cases. And of course, Brooks versus City of San Mateo was the biggest like gut punch, I think, to a lot of people. And I actually had the privilege of reaching out to Patricia Brooks, and she was really involved in this bill moving forward. And I think it was really helpful for her to be able to kind of seek that vindication after all these years. And so what we did first and foremost, and I highlighted this here, is that we made sure that this didn't just apply to sexual harassment, that this applies to all laws governing harassment, whether it's race, disability, sexual orientation, any protected category. And I cannot stress enough that I think it's really important. We are multidimensional beings. I think if you limit it just to sexual harassment, you're going to make it really difficult for practitioners. I think a lot of you on this call are practitioners, so I think you can appreciate that. And then the other thing is that we wanted to shift away from this frame of sexual harassment being about sexual come-ons, that someone was sexually attracted to this other person, but that really sexual harassment was about power. And it was really about preventing women from having an equal opportunity to succeed in the workplace. And I don't want to overwhelm everyone with all the text of the bill, and so I just highlighted it here, but I think it is actually worth reading through. So not only did we find the bad cases and have the legislature explicitly reject those cases, but we also found some really great language that we wanted to codify, that the legislature was essentially affirming that, yes, this is what sexual harassment means. And so we found this great, it was actually an administrative decision that says that sexual harassment is when it disrupts the victim's emotional tranquility in the workplace as to affect the victim's ability to perform the job as usual or otherwise interfere with and undermine the victim's personal sense of well-being. And I've heard time and again now since we passed this bill that not only in sexual harassment cases, but in a variety of other cases, that emotional tranquility language has been so helpful. We have some laws developing with intentional misgendering and things in that law is developing. And so having this new language really is going to help guide that development of case law. Okay, next slide. So the other thing that we did, so this again goes to the Brooks v. City of San Mateo decision, we wanted to make it clear that a single incident of harassing conduct is sufficient. So you can't reject a case because it just happened once. And here again, the legislature explicitly rejects the Brooks v. City of San Mateo decision. And again, kind of goes back to this idea that harassment really is about unreasonably interfering with the plaintiff's work performance. And then the next part that we went to, also harkening back to some of the bad cases that we've heard, is that it shouldn't depend, or that the existence of a hostile work environment depends upon the totality of the circumstances, and a discriminatory remark may be relevant circumstantial evidence of discrimination. And so I know there were some other cases that were saying, oh, these were just mere comments, but that information could be relevant and important to establishing your sexual harassment case. Okay, next slide. So the next one is, this goes to the Kelly v. Conco case, which involves sexual harassment in a construction work site. And we also, folks may know of the Lyle versus Warner Brother decision, where she was in a writer's room and they were like vulgar and probably boorish, using that term. And so some of the courts have said, well, you know, this is conduct that you just need to put up with, because that's just the nature of that particular workplace. And what we wanted to make clear is that it shouldn't, that the legal standard should not vary by type of workplace, that you shouldn't have to kind of immunize yourself from, you know, from these horrible remarks just because they're made over and over and over again. So I think that's also another element that we saw courts really hanging their hat on, that we wanted to take away. And then the last part was that harassment cases are rarely appropriate for disposition on summary judgment. And so, as was explained with the Brooks v. City of San Mateo decision, where basically this all was decided on summary judgment, it went all the way up to Justice Kaczynski. These are cases where a jury really needs to decide, and especially now, when again there is this awakening, and there is such a sea change in terms of what is sexual harassment. I think we need to put that before jurors. And so we codified a really good Court of Appeals decision, Nazir versus United Airlines, that basically said that the observation that hostile work environment cases involve issues, or sorry, that basically sexual harassment cases should not be determinable on paper. And I've heard a lot of our attorneys say that that's been really helpful, avoiding summary judgment. So I will stop there to give you that brief overview. We did a lot of other stuff, and I'd be happy to talk to folks offline on a lot of the other improvements that we made to our sexual harassment laws, like extending the statute of limitations, addressing confidentiality, you know, gag clauses, and, you know, still there's work to be done. So we're constantly working on this still. I'll pass it over to Miriam.
So, hi, everyone. It's a pleasure to be here. I'm Miriam Clark. I'm a partner at the law firm of Ritz Clark and Ben Asher in New York City, and also the chair of the legislative committee of NELA New York. We're the New York affiliate of NELA. We have about 350 members. And our legislative committee is all volunteer. We have no staff. And so I wanted to talk to you a little bit not only about what the amendments were that we achieved to the New York State human rights law, but how we got there, because I thought that might be helpful for people in other states who are wondering what the steps might be or what the process might be. So next slide, please. So the New York State human rights law is a very old law. As you can see, it predates Title VII by many years. It was very forward thinking, of course, when it was enacted, but by the 2000s, it was a complete anachronism. So it did apply to small employers, smaller than those covered by Title VII, but there were no attorney fees, no punitive damages, and the judges absolutely followed whatever they thought the federal case law was with regard to not only sexual harassment cases, but sex discrimination cases and discrimination cases of all sorts. For example, there was a general adoption of Farragher-Ellerth, the severe or pervasive standard, sometimes called the severe and pervasive standard, et cetera. And so, you know, if you were a practitioner, especially outside New York City, dealing with a small employer, this was really your only recourse. And other than that, the statute was more or less a dead letter for years. Next slide, please. So, as part of an overall women's equality agenda in 2015, which is pre-Me Too, there were some changes made across the board, including changes to the human rights law that completely focused, as you'll see, on sexual harassment and discrimination. So practitioners were allowed attorney's fees in sex discrimination cases only. Independent contractors as well as employees were protected from sexual harassment, And the 4-employee minimum was eliminated for sexual harassment cases only. So now the law covered very, very small employers with regard to sexual harassment. Now, one thing that's interesting here is that you'll see there has been what I've heard referred to as a norms cascade since 2015. I think nowadays, on its face, provisions that separate out or give preference to one form of harassment or discrimination over another without regard to intersectionality, I think would be red flag. But this was 2015, and this was the extent to which we could get the law advanced back then. Next slide, please. In 2018, right in the middle of the height of the Me Too movement, there were a couple of small changes made to the executive law. There were restrictions on non-disclosure agreements that settled sexual harassment cases. Basically a 21-day waiting period, sort of like the one in Owabapa, and a provision that purported to ban mandatory arbitration in sex discrimination cases, which, because of the FAA, I think everyone understood would have a hard road to hoe in terms of being enforceable at all. Now, what was going on in the meantime was that the New York City human rights law had been completely overhauled throughout the 2000 aughts. And there had been several changes in the text of the New York City human rights law and a lot of really groundbreaking decisions, so that by 2018, the severe or pervasive standard had been eliminated under the New York City human rights law, first by case law and then by statute. And the New York City human rights law had also eliminated the Farragher-Ellerth defense, again, first by case law and then by statute, and had a lot of excellent language about the remedial purpose of the law, and also excellent language explaining that discriminatory harassment is really just discrimination in the terms and conditions of employment. And one doesn't need to look at severe or pervasive, one simply needs to look at whether members of a protected class are being treated worse than members of a non-protected class. The New York City human rights law had eliminated severe or pervasive and replaced it with an affirmative defense that the employer had to show that the conduct was merely a petty slight or a trivial inconvenience. And so that was huge. And that set the stage for the changes that we proposed to the New York State law. Next slide, please. So at the beginning of the 2019 session, there was a broad coalition of groups that were determined to bring the New York State human rights law as close to the city law, essentially, as we could. And the coalition included a remarkable group of women called the Sexual Harassment Working Group, who were all, they were almost all women, and they had all been legislative aides in the New York State Senate and Assembly, and they had all been harassed. They'd all complained of sexual harassment. And so they were incredible advocates, both because they had worked in the legislature. So they knew all the legislators, they knew how the legislative process worked, and their stories were incredibly compelling. And so NELA New York and other organizations partnered with the Sexual Harassment Working Group. And the original draft legislation, we simply took the New York City human rights law and the New York State human rights law, and with a red pen, a couple of NELA New York members started marking up the state law to make it look like the city law. So these were some of the things that were in that initial draft that became part of the final legislation. You can see severe or pervasive gets eliminated and the affirmative defense that I mentioned before gets substituted. We included independent contractors. We extended protection to domestic workers from all forms of discriminatory harassment. Next slide, please. We, again, modeling this on the New York City law, broadened the human rights law to include attorney fees, to include punitive damages. And then we added language similar to that in the city law that explicitly stated that the law should be construed liberally to enforce its remedial purpose, that federal case law should not be followed. We said that explicitly, and that any exceptions to the law should be construed narrowly. Now, one of the things that advocates were doing here is eliminating the differences that had existed before between sex discrimination and other forms of discrimination and harassment. This was a fundamental, both to our views, to those of the Sexual Harassment Working Group, to those of the sponsors of the bill. So next slide, please. We actually went further than the city law in that our bill covered all employers. So we eliminated the 4-employee minimum altogether. And we added language that specifically states that failing to complain of discriminatory harassment is not determinate. And this was, we had a larger effort to try to eliminate Farragher-Ellsworth altogether, which we could not persuade the legislature to do, but we were able to get this language in because there was so much case law in which incredibly painful harassment was legalized because the employee had not complained properly. So this is the parts of the legislation that eventually passed. There were 2 public hearings both of which went on all day, that were the first one specifically about sexual harassment and the second more broadly. Neal and New York members testified at both hearings, and at the first hearing, I simply read to the legislators the horrible facts of many cases. We focused really on New York State cases, but of course they were all following federal law. And my testimony is in the materials, but I stood up there and just talked to the legislators about plaintiffs, you know, being called dumb blondes, being swatted on the butt, all sorts of really gruesome and awful conduct, plaintiffs' bra straps being pulled, rubbing lubricant on plaintiff's arm. I found like 3 or 4 truly disgusting cases and just started describing them to the legislators. And as Joan said, because public opinion has changed so much, the looks on their faces was really quite priceless. I mean, they were shocked and disgusted, and that's of course what we wanted. Afterward, at the second hearing, I ran into one of the legislators in the hallway, and he said, "I remember you're the one who said all that disgusting stuff at the hearing, right?" And yeah, that was me. So at the second hearing, we became concerned that the legislature and the governor might, because of public opinion, be willing to pass sex harassment legislation, but not broaden it to include racial harassment and other forms of discrimination. So Neal and New York members testified at the second hearing as well. It was Lori Morrison, who I think is on this call, and focused really heavily on the issues of intersectionality, on the issues of how sexual harassment absolutely affects women of color, and also the incredible difficulty for practitioners of having different standards for one form of discrimination and not another. So next slide, please. So the bill passed, actually it passed unanimously at the end of the 2019 session. And what's left are these pieces which we essentially were told had to come out of the bill. The most important really is the first one, which is we really, really wanted language, which the New York City human rights law has, that employers would be absolutely liable for the acts of their supervisors. That's completely codified in New York City law. And we could not get that. We had legislators who were concerned, I think, about themselves or about small business people and their families. Many of them seem to believe in the sort of one bad apple concept, the idea that an employer would be responsible for the act of one bad apple. So this is not an issue that we're going to drop, but it was probably the biggest disappointment that year. Also, and this is interesting, we could not get the legislature to agree that domestic workers would be protected from all forms of discrimination. This was really shocking. Domestic workers are currently, as a result of the new law, protected from all forms of discriminatory harassment, but not all forms of discrimination. And finally, we really wanted language that set the standard as a motivating factor as opposed to but for, which is the standard in Gross and other cases. We did not succeed there as well. I think partly the argument was a little complicated. Legislators needed to know a lot more about what the current law was, and as we know, it's sort of all over the place. But that's something else that we want to revisit as well. I think that is it. Is there another slide? No, I think not. Oh yes, here we go. Sorry, other related provisions. So these provisions also got passed in 2019. The restrictions on NDAs were broadened to include all forms of discrimination, the mandatory arbitration provision as well. There was mandatory training, a model policy, and an extension of the statute of limitations for filing with the State Division of Human Rights from 1 year to 3 years. So that's where we are now. We have a long to-do list because the law can certainly be improved. But this was a significant change in the law that really would not have been possible without a broad coalition of advocates and a legislature that I have to say was really devoted to making a difference once they heard what the problem was.
Yeah, and Miriam, if I jump in too, one thing that I wanted to make sure was conveyed for folks that are thinking about passing legislation is some states may have the actual severe or pervasive standard codified in their state sexual harassment laws and others may not. We actually did not have severe or pervasive codified, and so there was a lot of discussion about whether we codify that and then go through what that standard means. But I actually think if you're facing a lot of headwinds from maybe more conservative members, that actually sticking with the severe or pervasive standard and then again just defining it in a way that doesn't sound so severe or sound so pervasive, you might have an easier time getting it through. So you're actually, a lot of what we said in our lobbying efforts was that we weren't changing the standard, we were just providing guidance to courts who were getting it wrong. And so I think, again, just a tip as something that might be effective and useful, because there might be a lot of, I think especially, the pendulum has it's felt like it's kind of is swinging back the other way and there's a pushback. So you might face some resistance in changing or this perception that you're radically altering the standard of sexual harassment. So all these like very sensitive people are going to be now flooding the courthouses, as a way to push back against that. Just one comment I just wanted to make sure to make.
We were able in some ways to avoid that problem because the New York City human rights law had already been in effect for a while. So actually at the hearing, we had someone from the New York City Commission of Human Rights talk about that the new law, had no discernible effect, for example, on the New York City economy, that it wasn't causing employers to go under, that employers were not complaining. So I think that as more states change their laws, that sort of helps people in states with older laws say, look at the state of New York. The economy of the state of New York has not tanked as a result of this. It's been good. Employers are praising this, et cetera. So, but as I said, we were incredibly lucky that a lot of the groundwork had been paid for us by the New York City human rights law.
Well, thank you, Mariko and Miriam. Thank you all of you for your fantastic presentations. We're going to turn it over now to the Q&A portion of the webinar, and some folks on the line have sent in some terrific questions. So I'm going to start with those. And I think the first question is probably most for Joan and Jennifer, but any of you can speak up about this. And I'm going to try to summarize the question. The question is basically this: for the litigators on the line, how can folks go about convincing the hearts and minds of judges, many of whom are, maybe older, they are, wedded to these cases, even the bad cases that we've been talking about in this presentation. How do we go about strategically bringing up to these judges that it's time to take a fresh look at these standards without compromising, our desire to do the best for our clients in these cases?
I'll take a first stab at that question as a litigant, and Miriam may have some thoughts as well. I know you've litigated these cases, many of these cases, and Joan, I know you have thoughts as well. But I think one of the most important things is just to throw all of the spaghetti against the wall, because judges all think so differently about cases that one set of facts on one case might be really persuasive to one judge, one conservative judge, but a legal argument might actually be really persuasive to another really conservative judge, right? And so you have to give them every opportunity to find something that resonates with them. In the same way, when you're in an oral argument and you go through these things and all of a sudden you see something kind of catch their interest and you get the nod of your head and you realize that something has actually sunk for them. I think one thing also is to try to, there's this trial technique that is referred to polarizing the case, which is usually referring to, are you saying that my client is a liar or not, and getting them to take a side. I think you could do something like that, similar with the judge. Are you saying that use of racial slurs is not racial harassment? Is that what you're saying? Are you saying that groping is never sexual harassment? Are you saying that this set of facts would not be considered sexual harassment today? And force them really to take an unpopular stand. If they're going to rule the wrong way on a case, lock them in it. And I think it reminds me a little bit of what happened in the Brock Turner case, where Judge Persky sentenced Brock Turner to a very short sentence for sexual assault. And there was such a powerful backlash that he got recalled. And so not that that's something that we want to be wielding, but I think the judges are very concerned about how their decisions are viewed by public opinion. And that is something that I think is entirely fair game to use. Another thought is to, of course, cite Joan's article. Definitely cite it, include it. Don't just cite it, actually print it out and put it in as exhibits so they don't have to get it. Cite other kinds of empirical evidence because that's persuasive. A last thought is, there are a number of white shoe firms that are starting to do these kinds of plaintiffs' cases. And so, in many parts of the world, seeing the right name on a brief will be more persuasive to a judge. And so, it's a sad fact of our world, but if you are able to get particular partners to do, say, a pro bono or an amicus brief, and that could be another way to get your case looked at slightly differently by a judge who may pay more attention to relationships or politics as opposed to the substance of the case. So just a few thoughts.
Yeah, I also had some thoughts. I did a sexual harassment workshop for the Ninth Circuit judges and helpfully put piles of the law review article in the middle of the table. And when I started to talk through slides about the polling data, they were picking up the article and looking in it. I do think this polling data is very persuasive. And I always recommend a kind of, you guys, the litigators, but a kind of tone of sincere regret of like, that's kind of not what people believe today. And if we got numbers in the 70s or 80s or 90s of people on the other side, that's just the test. The test is a reasonable person. And the summary judgment test is what could a reasonable, and it's pretty clear what a reasonable person would say today. I don't know if that works, but that's what I would do.
Thanks. So another question that we had come in chat was about if they had paid for a lobbyist. And maybe I'll just expand that to ask if Mariko and Miriam, you can give folks some practical advice about how they can, get involved in some of this legislative advocacy. You all have, dedicated a lot of time to it, but maybe you have advice about how attorneys who don't have that as such a big part of their practice can connect to folks who are doing this kind of advocacy and get involved in that way.
I guess I can start by saying that NELA New York is an incredible organization and with enormous sort of range and depth of experience. So having 25 lawyers on the legislative committee really makes a difference. It means that there's no one person who has to do all the lobbying, all the testifying, et cetera. So number two is that we've built relationships with certain legislators, which is not that difficult to do. State assembly people and state senators are not really used to hearing from their constituents. So a really good idea for a bill will often get a real thought and hearing, especially from newer legislators who are trying to make a name for themselves. And that's something that's very easily accomplished. It's also important to see that these things take years, right? So we were in the women's equality agenda argument 5 years ago, and it took many years to whittle away at severe or pervasive. So you have to be thinking sort of, I think, in the long term. And relationships with other advocacy groups are really important. So we at NELA have strong relationships with groups in New York and nationally, like NELP, the National Women's Law Center, as I said, the Sexual Harassment Working Group, NICLU, just to mention a few. And so joining with them is enormously helpful. We get the benefit of their experience, their staff, and they get the experience of our real life on the ground advocacy experience.
Yeah, and I would say it's easy for me because this is my full-time gig. I am in Sacramento. I work at the state capitol. But from my experience, I would say it is never too late to try to develop those relationships with coalition partners and with your state officials, your state representatives. So what I would suggest is if you're in, say, a NELA affiliate, a NELA state affiliate, I would have folks on your, the next meeting you have, identify who your state representatives are at your state house and try to identify the ones that are, that you think would take this on. And honestly, I think a lot of people don't fully appreciate how open and welcoming that these state representatives are in listening to what their constituents have to say. And if it doesn't result in a bill, I'm just gonna make this plug because at least in California, we've been seeing the number of actual lawyers really dwindle. And so, and I think that's really, it's a little troubling because these are the people who are making the laws. And so I think there needs to be more of an effort for lawyers to reach out to their elected representatives and talk about what's happening in these cases, what's happening in your case. And again, usually what should happen, because if you can find that good progressive office that wants to do something on sexual harassment, they will know who the active organizations are that have a full-time person in the state capitol who's working on these issues, and then you just connect in with them. And I think you're gonna find some success. And even if it's not successful the first year, just the fact that you're developing those relationships with, again, and forming that coalition, years down the road, it's gonna prove to be a worthwhile effort, not just with sexual harassment, but a variety of other employment law issues that you might want to tackle through state legislation.
Just to sort of add to that, if you do this enough and you have enough relationships with legislators, especially the ones who are not lawyers, but even the ones who are, they'll call and say, someone has suggested this bill. What is NELA New York's opinion on this bill? Does this bill really address the problem? Does Neil in New York have any other ideas for how we might address the problem? And that's enormously helpful. This sort of sharing of ideas, or the same thing we'll do. We have an idea for a bill. What do you think? Do you think it will fly? Who do you think a good sponsor would be for the bill? What can we do to advance the bill? Have other advocates been talking about this? And keeping those relationships open year after year is enormously helpful.
Great. Thank you all for that. We're having a lot of interesting questions come in to the chat, so keep them coming. I will look at them. Thank you, everyone. Here is one that has come in, which I think is interesting and tough, and I think maybe all of you might have advice about this one. One of our audience members asks for advice on advocating for victims of sexual harassment in a sexualized workplace, like exotic dancers. What do you all think about that? How does that affect what kinds of advocacy you do, arguing about what is reasonable, what is severe or pervasive?
I mean, I would just go back. I mean, I'll leave this to the practitioners, but you know, it was so ingrained in the way we were framing our bill that this is really about equal opportunity to do your job, interfering with your work performance. And I think if you tie it back to those concepts, then in my mind, I think that's the best way to advocate.
And of course, on call, you have that language of a reasonable person in the plaintiff's position. I mean, even if you're an exotic dancer, you don't expect to be treated as the property of everybody who happens to walk up. That's just kind of not the deal that you sign up for. Going back to Mariko, it's like, this is the job that I was hired to do, and this isn't part of that job.
I think it also bears emphasizing the difference between receiving sexual attention from patrons versus receiving sexual attention from coworkers and superiors. Even if part of the understanding of the job is that it is to elicit sexual attention from patrons, it does not make it okay for your coworkers and your superiors to treat you in that way. And there was a case cite, it's the Williams versus General Motors case in the Sixth Circuit that talks about how it shouldn't matter what industry it's in. And I know that there are other sites like that that say that the industry shouldn't matter. Women should not have to be subjected to this kind of treatment just because they want to work in a particular industry.
That was a blue collar context, but it applies equally here.
Okay, I'm going to raise a question that someone has put in the chat, which is this is a big one. And maybe you all will have something to say about this sort of broad and tough question. I will just read it because I can't improve on the wording of this question, which is this: how do we change the law and culture so that our clients don't have to leave their jobs to be safe from sexual harassment?
The ultimate question.
Yeah, no question.
I mean, I do think that business is a, sorry, Mariko. I mean, one of the first, I wrote a lot in Harvard Business Review. So I spent a lot of time talking to people in business. And I think, you know, the strong message for business is people need to be able to show up and do their jobs. That's all that we're talking about. We're not talking about anything radical. We're just saying, if you sign up, I signed up to be your colleague, not your girlfriend. That's all we're asking. Sorry, Mariko.
Oh, no, I was just going to say, I mean, I think it needs to be a multifaceted or multifrontal attack, you know, that we're attacking it from the policy perspective, from sort of social media, from the press, from litigation, and we're all sort of coordinated. And I do actually think I've heard a lot that businesses have really changed their practices since I mean, again, there's a lot of different things that are influencing this, but with our bill, with SB 1300, I think honestly, the big kicker was that, you know, a single incident of harassing conduct can be a triable issue. And so I think a lot of employers felt like you can kind of let things slide or let things pass, and if it gets bad enough, then we'll take action. But now the fact that you're not even, potentially you're probably not going to be able to resolve this through a motion for summary judgment, that you're going to have to like go through litigation potentially because you didn't address this one incident. I've heard, and this is from the defense side, and a lot of different conversations, that it has really changed how businesses are conducting operating their workplaces.
I guess I agree completely with that. I also would want to say, I guess, two things. First of all, we had data that we presented to the legislature that a hostile work environment is actually bad for business, that employees who suffer from hostile work environments are less productive and they leave their jobs. And in fact, even people who witness hostile work environments, in other words, someone who's just a witness to someone else being harassed, is less productive and more likely to leave. And I think that really needs to be clarified and absorbed. That's number one. And number two, I don't think that you can separate sexual harassment from the larger questions of economic equality and occupational segregation that affect, not only women versus men, but people of color as well. So I think it's a mistake analytically to focus solely on sexual harassment as if it were some strange animal in the workplace that was unrelated to issues of power, issues of job segregation, et cetera.
One thing to consider doing more of is representing employees behind the scenes. So I represent a number of people who are actually going through sexual harassment or just experienced sexual harassment, but they're still employed. And there's still an opportunity for the employer to handle it in a proper way. And what oftentimes happens is once the complaint has escalated to a certain point, or once counsel has appeared, that there is a lack of trust and a breakdown in the employee-employer relationship, that the person just can't stay. It's just not practical. There's always going to be a fear of retaliation. There's going to be grudges. And that's, of course, messed up. That is a problem that needs to be fixed at a larger, more systemic level. However, on a case-by-case basis, I will oftentimes just help people behind the scenes to say, well, this is what's going to happen. This is what the investigator is going to ask you. This is what you should say. No, don't send that email. Let me ghostwrite that for you and make it sound like you. And let me put in these typos to make it look like it's not an attorney. And I just had a case where I thought it was going to be a great case, but then the company started doing the right thing and they fired the harasser. And she was supposed to be laid off, not because of the harassment, but then they gave her another job. And so, that was actually a contingency case, but I said, you know what, hey, you got a job. Glad I was able to help you. I even told her, you could make a donation to the Center for Work-Life Law if you'd like to repay us. But other times you can do that work for people who have the ability to pay on an hourly basis. And I have seen it work on a case-by-case basis.
I wanted to share another really positive story. In the middle of Me Too, a law firm partner called me up and said, there's this big rainmaker from our firm who we finally booted out because of sexual harassment. And now he just went and got this huge salary at another firm. You have to do something about it. And I said, this should be the recruiter's job. And then I heard from her about a year later, you know what? You didn't have to do anything about it. Now, when law firm partners are changing firms, they have to affirm that they have had no sexual harassment complaints. Problem solved. And so I do think there's been a really profound shift in business norms, which of course is more powerful than all of us could do together.
That's a great story. Those are great stories. And I feel like we can't choose a better note to end on than thinking about how to change culture. And I love the ideas that you all threw out there about approaching it from many different angles. I think that's absolutely right. And looking at the chat, one of the things that is energizing me is thinking about connecting the different kinds of folks who are presenting and on the line here. You all are doing work that touches on all these different levers that are ways that we can change hearts and minds and change culture. So I will offer up myself as someone at the Time's Up Legal Defense Fund and is connected to all of you in various ways. If people in the chat want to connect to others, as I'm seeing come through the questions, you may reach out to me and I can help you to do that. I think, for example, we have an interesting mix of folks doing litigation and plugged into state legislative work, and it could be really interesting and powerful to get you all connected in different ways. So think about that, and I will offer myself up as a way to connect folks who wish to be connected. Thank you again to our fantastic presenters. I thought this was a really rich discussion. I learned a lot. Everyone in the audience, thank you for staying engaged and asking really terrific questions. The recording of the webinar and the materials, including the list of cases that Jennifer mentioned, Professor Williams' article, a copy of the slides, copies of the testimonies before the state legislatures, all of those things will be posted on the National Women's Law Center website in the not too distant future. So look out for that, and hopefully that will be a resource to you all going forward too. And with
One
that,
final thing, Jennifer, if people wanted to support my institute, the Center for Work-Life Law, one thing you could all do is write me into the sexual harassment trainings that I give, and I have given to the Ninth Circuit, into whatever. It would be very helpful to us, both in terms of mission and financially. So thank you.
that's a great idea. And I have had some people in the chat asking, Professor Williams, if you can do trainings for the judges in their circuits too. So perhaps
I already have the training. Happy to do that. Happy to do that.
All right. Thank you again, everyone. Stay safe and well, and stay tuned for future webinars in the coming months. Thanks, everyone.
Thank you.
Thank you.